credit.
Waynet,
I know, but that's what eventually got it. Okay, name spelled correctly? Okay. Today's date.
Hey,
I forgot the headphones, so, he's on his way back over there to get them.
Bruce put on, for offense.
Say what now?
Name spelled correctly?
I forgot the headphones, and so, Fabio's on his way back to get them.
Okay, got it.
So
Mr. Montenegro, how are you, sir? I appreciate you being here at 1 o'clock for us. And then have a little bit of a reschedule. All right, I'll tell you what, while we're waiting, let me go ahead and swear you in before we get you testing out the defendant. You'll go ahead and raise your right hand and state your name and your license number. Mr. Montemayor, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter, now on trial to the best of your skill and judgment, so help you God? Thank you, sir. All right, you want to go ahead and see if you can establish some line of communication with the defendant, Mr. Murillo? Make sure you are in the Spanish channel.
Yeah, I'm on Spanish on the computer. Hang on.
Make sure his inline microphone's not muted.
Okay.
Better.
Yes, Your Honor.
Yes, yes.
Great, excellent. All right, the court calls cause number CR 22-191, State versus Jaime Murillo Barrientos. Mr. Manning, we are set today for pretrial. Go ahead, sir.
Yes, Judge, at this time, we have no contested pretrial issues. We request to be set on the docket call. Additionally, Judge, there was some question as to my client's immigration status. And we request that part of this reset be so that we can get with an immigration attorney to discuss and make sure he's advised under Padilla standard what the status of his immigration would be under a conviction for this offense.
Okay, thank you, Mr. Manning. All right, then court will set Mr. Murillo for docket call on November 9th. Suspicion, Mr. Manning.
Judge, if we could have a little bit longer because of the immigration issue.
December 14th.
Judge, that'll work.
All right, court sets the defendant for docket call on December 14th. And we'll just set that at 2:30. And that way I can try to arrange for another interpreter. Mr. Montemayor, once you get a chance, can you ask Mr. Murillo if he has any questions of his attorney or the court that we can assist with?
Okay, so. No, sería todo. Todo perfecto.
Okay, and we'll see you again on December 14th at 2:30. Mr. Montemayor, again, I appreciate you being here. All right, great, thank you. There's nothing. No, sir, I think that's the only one we have today, correct, Mrs. Abraham?
That's correct, Your Honor.
That'd be all for us, Victor. Appreciate you, sir.
Mr. Bell?
All right, Mr. Stevens. I believe you're here on a writ, is that correct?
It is correct, Your Honor. We're here to try to seek bail reduction.
All right, this is writ WR 23-77. James Aubrey Hornbuckle versus State of Texas. Go ahead, Mr. Stevens. Do you want to call your client?
Yes, Your Honor. I'd like to swear my client in.
Sir Hornbuckle, if you'll raise your right hand, I swear you in for the purposes of this hearing. Mr. Hornbuckle, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, make sure you speak up loudly and clearly, please. Otherwise, I can't do anything that you're asking me to do. Go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
James Hornbuckle,
James, how long have you been incarcerated now?
75 days.
75 days. You're being held on a $15,000 bond. Is that correct?
Yes, sir.
Evading?
No, it's for that charge.
I apologize for a theft charge. Okay. Now, been in jail 75 days. You've not been able to post that bond.
No, sir.
Do you have any cash that you could put toward the bond?
Not at the moment.
Do you own any property that you could sell or pawn to help put toward the bond?
No, sir.
I understand you got some tools, but they're your working tools, correct?
Correct.
Okay. Now, speaking of working, how about employment? You have a job.
Yes,
Okay, who would that be working for?
a friend of mine doing hospital.
Okay. And you actually have that job? I mean, you've discussed it with him? Okay. And how about transportation to and from the courthouse? How would you get to and from the courthouse?
My wife's vehicle.
Okay. And you have a place to live, correct?
Yes, sir.
You'll live in Wills Point. I believe you told me that y'all are waiting on a new address that's gonna pop in about another
On
week.
the 18th.
18th, okay. So on the 18th, you'll have I mean, you have an address to go to now, but you just don't know the actual number.
Yeah, I do not know the physical address.
Okay, all right. And you got young children to support, that correct?
Yes, sir.
You have 4 minor children,
Well, I have two minor children.
2 minor children, and you're currently paying child support.
On the other 2.
Okay. Are you asking the judge to, well, first of all, if the judge does reduce the bond, can you assure the court that you will make all of your court appearances?
Yes, sir.
Have you ever failed to make a court appearance that you know of?
No, sir.
Okay. Are you asking the judge to reduce it to $5,000?
Yes, sir.
Is that an amount of bond that your employer has already told you that he'd be able to post for you?
Yes, sir.
Okay. That's the witness, Your Honor.
State you're with us.
Thank you, Your Honor. Mr. Hornbuckle, the address that you'd be moving to, would that be at all in violation of any pretrial release conditions regarding victim contact or anything like that? Okay. No further questions, Your Honor.
And Mr. Hornbuckle, do you have any criminal history?
No, I have an evading arrest charge that was deferred 21.
2021, are you still on probation for that?
I completed that.
You completed that and the case was dismissed.
Yes, sir.
I show you actually being held on 2 charges here in Banting County. One is theft of property, $2,500 plus $30,000 with a $5,000 bail, and the other being theft of property, 100 to 750 with bail of $15,000. Is that correct? For a total of 100.
And on the misdemeanor case, he's been granted a PR bond for the 30-day delay. So what's holding him in that jail now, Your Honor, would be this case.
Am I incorrect? The jail sheet is showing that his bail is already set at $5,000 on the more serious felony charge, and that the misdemeanor charge was set at $15,000.
I think they got the bonds backwards or something on the paperwork.
Yeah, Judge, when we filed our paperwork, we thought the misdemeanor bond was 5,000 and the felony bond was 15,000. That's what we filed, and that's what our assumption was at the office.
Ms. Taberhand, can someone at the jail confirm or deny whether or not those have been switched up? Because the jail sheet is showing that it's 5,000 for the felony. I don't want to set something that's already set.
Let me go check.
All right, while we're waiting on that, state, do you have any argument as to why the court should not set bail at $5,000 for Mr. Marlowe?
None, Your Honor.
Does the state oppose the defendant's request?
No, Your Honor, no opposition.
Okay. All right, then the court will grant, if in fact the bail is not already $5,000, the court will grant the defendant's request and set bail at $5,000 for theft of property, $2,500 less than $30,000 cash or surety.
Thank you, Your Honor.
All right, and once I get information from Ms. Taberham, if I need to sign an order reducing it to 5,000, I will. It was already set at 5,000, and you should be able to post that at any time.
Sounds good, Judge. Thank you, sir.
There you go, students. We have any other attorneys that are ready?
After the Jonathan Lassiter.
All right, this is cause number CR 20-258, State versus Jonathan Russell Lassiter. Court finds that Mr. Matt Hawkins is counsel for Mr. Lassiter, and that he is set on a motion for vote. I'm assuming Mr. Hawkins, you were just retained on the case, so you're not ready to proceed on that motion, are you?
Your Honor, I was retained this last week and I had difficulty getting the appearance in. The e-filing system was down, so I was able to get it to the clerk yesterday. I do need additional time. I'd like to be able to speak with the prosecutor on it if we can first, Your Honor. And I guess if it goes to a contested, I'd like to have, I guess, go ahead and have a setting on a contested docket just in case we're not able to work it out, so we can try to get him out sooner than later.
Okay, what we could do is my next contested docket is in 2 weeks from today on the 26th. That's coming up pretty quick. I can set it as early as that for contested hearing. I've also set it for November 30th and give you another setting between now and November 30th for a status. You know what you want to do on that?
If we can do the 26th, Judge, get it done in that time. Speak anyway.
All right, the court says Mr. Lassiter then for contested hearing on October 26th. That'll be at 1:30 over at the courthouse, if it is a contested matter.
That's all I have, Your Honor.
All right, thank you, Mr. Michaels, and we'll see y'all back on the 26th.
Thank you, Judge. Be excused.
Yes, sir. Thank you.
Okay, Your Honor, on Mr. Hornbuckle, the less than $750 is 15,000. And the less than 30,000 is the 5,000.
So it's correct on the jail sheet.
That's what the jail shows.
Okay, but I guess my question is did they verify that with the magistration form? That the magistrate signed? Because it seems like that would be opposite.
No, I will go check and make sure.
Yeah, I don't want them just to check their screen. I want them to check where they got the data that they input to the screen from the magistration packet.
Okay, and Mr. Manning is reading.
All right, Mr. Manning, I'm ready for you.
Judge, ready on Mr. Mitchell?
All right. To it. This is cause number CR 21403, CR 21406, State versus Kate and Robert Mitchell. Let's see, Mr. Mitchell, you also have another middle name, correct? Everidge, is that correct?
Sure.
Okay, all right. All right, and this is still gonna be a plea today, Mr. Manning?
Yes, Judge.
All right, Mitchell, if you'll raise your right hand, I'll place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right. All right, Mr. Mitchell. In cause number CR 21403. You appeared before the court on May 10, 2022. You pled guilty to prohibited substance for out of the correctional facility, a third-degree felony. The court heard a plea agreement that day, along with the evidence. The court, based on the plea agreement, placed you on deferred community supervision for a period of 2 years, and also a fine of $2,500. Because of CR 21406 on the charge of driving while intoxicated, second offense. You also appeared before the court on May 10, 2022. You pled guilty to that offense. The court heard the evidence in the plea agreement, followed the plea agreement, and assessed your punishment at 1 year confinement in county jail. The court also imposed a $100 fine. The court then suspended that sentence, placed you on community supervision for 2 years. In each one of these cases, the state has filed a motion to revoke your community supervision. Do you feel like you've had enough time to review that motion with your attorney, Mr. Jonathan?
Yes, sir.
You feel like you've had enough time to meet with them about these allegations against you, and that you understand all of your legal rights, and you understand everything that you've read and signed with your plea agreements?
Yes, sir.
Are you pleased with Mr. Manning and the work that he's done for you as your attorney?
Yes, sir.
Mr. Manning, if your client intend to waive the formal reading of the motion to revoke, and also please show all counsel team there.
Judge, he does intend to waive. He intends to plead true to all counts listed in the judgment. However, the state has agreed to abandon counts 1 and 12. In number 403, has agreed to abandon count 1 and 406.
Count 1, and what was that last word? 406?
12. I believe it's 12. Yes.
I'm only showing, let's see, I'm showing, okay. I failed to report.
Count 12 is a new offense. And count 1 in 403. For some reason, they didn't allege the same motion to adjudicate in 406. Just count 1 on motion to adjudicate 406, 1 and 12 on 403.
All right, let me repeat that. There's a little breakup. What I'm hearing is that the state's agreeing to abandon counts 1 and 12 in cause number 403. That's its felony prohibited substance. In 406, which is the DWI, the state's agreeing to abandon count 1, alleging a new offense.
That is,
And that's the only new offense I see alleged in that motion, correct?
that is correct.
So 1 and 12, and then just, okay.
And the judgment accurately conveys that on both judgments. I checked that and it is accurate for both of those.
All right, I think it's me. All right, Mr. Manning, do you believe that Mr. Mitchell is competent today to enter into these plea agreements? And that you believe he's doing so intentionally, knowingly, and voluntarily after you've explained to him his rights and circumstances regarding his agreements?
I do, Judge, and he is.
All right. All right, in cause number 403, Mr. Mitchell, the court finds that you have waived the formal reading of the state's motion to vote. So at this time, I would ask you, how do you plead to counts 2 through 11? Are those counts true or not true?
True.
And in 406, which is your driving while intoxicated case, how do you plead to counts 2 through appears to be 13?
True.
And Mr. Mitchell, are you pleading true to all those counts in 403, also 406, because what's alleged is true? You're not just saying that to get a plea agreement, is that correct?
Yes, sir.
And Mr. Mitchell, has anyone threatened, force, pressure you to be true to any of these counts?
No, sir.
All right, the court will accept the defendant's plea of true in each case respectively. Mr. Manning, any objections to the admission of the defendant's waiver of right to plea of true?
No objection.
All right, those are admitted respectively. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Rest in closed, Judge.
All right, then based on the evidence before the court finds that Caden Roberts and Beveridge Mitchell has violated the terms and conditions of his community supervision in each case. Cause number CR 21403, court finds on that finding of true and finding that he has violated. The court follows the plea agreement today that Mr. Mitchell has reached with the state. The court adjudicates his guilt, convicts him of prohibited substance item in a correctional facility, revokes his community supervision, assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice. Court orders him to pay the balance of his financial obligations and awards him 12 days credit towards the sentence for the time that he's already spent in jail on this cause. In cause number CR 21406, the court finds that Mr. Mitchell has violated the terms of his community supervision. The court revokes his community supervision, assesses punishment in accordance with the plea agreement at 12 days confinement in the Bansing County Jail, issues him 12 days credit for time served, orders him to pay the balance of his financial obligations. Mr. Mitchell, you hereby remanded to the custody of the sheriffs. We can carry out the terms and conditions of the sentence. Once you get out of TDC, it's important that you report back to the courthouse clerk so that you can make arrangements to pay off these things. Failure to do so will result in the court issuing another warrant for your arrest. Okay?
Thank you.
Good luck to you.
Okay, Your Honor, I went and verified, and yes, that is correct.
All right,
It's- They are.
So the magistrate recommended $5,000 bail on the state jail felony offense. Okay, I'm trying to see that theft of property. I see, okay, that does appear to be correct. So Mr. Hornbuckle already has bail at $5,000. He was eligible as soon as he got his PR bond to post that. So you'll just make sure that Mr. Hornbuckle knows that if he's still in there. If not,
Okay.
Mr. Stevens. So I'm not going to sign a new order since it's already set that.
Just a moment.
Tell the jail I appreciate them looking that up for me.
I will.
Are you ready on now, Mr.
Judge, ready on Mr. Overstreet. That is our writ.
All right, Mr. Overstreet, if you'll come on up. This is writ number WR 23-83 Junior Street versus State of Texas. Are you going to be calling Mr. Overstreet testifying?
Yes, Judge.
All right, Mr. Overstreet, if you'll raise your right hand, I'm going to place you on both purposes of this hearing. Mr. Overstreet, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? Say it, I can hear you. Okay, well, all right. Make sure you speak up loudly and clearly. If I can't hear you, then I can't do what you want me to do. Go ahead, Mr. Manning.
Mr. Overstreet, you turn yourself in on this case, is that correct?
Yes, sir.
Scoot up and make sure you're talking real loud. And when did you turn yourself in on this case?
On the,
Okay.
And I'm sorry, I didn't catch this.
on the 19th of July.
Thank you.
And have you been in continuous custody since the 19th of July?
Yes, sir.
Okay. Have you been able to make bond in this case?
No, sir.
Okay. And what's your bond currently set at?
50,000.
Okay. Have you attempted to get resources together to try to make bond?
I tried.
Okay. And do you have any bank accounts?
No, sir.
Okay. Do you have any assets like a vehicle?
No, sir.
Any home you can put up for collateral?
No, sir.
Okay. If you were to get out on a PR bond, would you have a residence where you can stay that's away from the alleged victim?
Yes, sir.
Okay. And you understand that the court put a no contact order with you, the alleged victim, and anybody in that member's family?
Yes.
You understand that? And would you be able to abide by that condition?
Yes, sir.
Judge, I pass.
Stay here with us.
Your Honor, I have no questions, just argument.
Mr. Manning, anything further?
Judge, just briefly, I have one more question for my client. Mr. Overstreet, you've never been in trouble before, correct?
No, sir.
Never been arrested before?
No, sir.
Okay, so you've never had an opportunity to violate order of court. You've never had a bond jumping or bail jumping or any type of case where you didn't respond to what the court required you to do?
No, sir.
Okay. And do you agree, if you were granted a PR bond, you agree that you will abide by any and all conditions that are placed upon you?
Yes, sir.
No further questions, Judge.
Mr. Hartwell, still no questions?
No, Your Honor.
Okay. Mr. Manning, would you like to argue?
Judge, I would point to and ask the court to take judicial notice of the court's file. My client applied for and qualified for indigent status. You've heard the testimony today that he has attempted to make calls to get released through bond or through bail and has been unsuccessful at this time. A reduced bond would not help him in this situation because he has no assets. Everything has been taken or seized since he's been incarcerated. You also heard testimony that he's never been in trouble before. He has no criminal history, and so as such, we would request that he be given a PR bond and put on the conditions appropriate for this case.
Thank you, Mr. Manning. Mr. Harwell.
Yes, Your Honor. Mr. Overstreet in this case has been detained less than 90 days. We have a case that is set for grand jury next week. The charge in this case, continual sexual assault of a child under 14. My understanding is the punishment range for that is 25 years to life, day for day, no parole. So we believe that $50,000 in this case is not unreasonable bond, especially given the fact that we still are under that 90-day limit.
Thank you,
And
Mr.
Judge,
Go ahead, Mr. Manning.
I would just point out that while we're under that 90-day limit, grand jury will not meet before the 90-day limit is reached for my client. And so we were requested, if he is not given relief today, that the court carry over this motion to his 90 days and grant it at that point in time.
All right, Mr. Harwell, any response to Mr. Manning regarding whether or not grand jury will be held before the expiration of 90 days?
Your Honor, without a calendar in front of me, I can't do the math exactly.
When is the next grand jury?
Next grand jury is next Friday, Your Honor.
Next Friday?
Yes, sir.
Judge, I'm sure that will be October 20th. He was arrested on July 9th. Sorry, not arrested. He turned himself in when he was made aware of a warrant. He turned himself in that day.
Okay. All right, the court will take the evidence in the writ under advisement, and I'll issue a ruling at a later time. I may hold it in abeyance until his 90th day, but I'll notify the state defense either way what I'm saying.
Yes, Judge.
All right. Who's next, Mr. King?
Judge, if we can have next writ on Mr. Richardson.
All right, this is writ WR 23-82, Christopher Richardson versus State of Texas, and are you gonna be calling Mr. Richardson today?
I am, Judge.
Mr. Richardson, raise your right hand, sir. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. All right, go ahead and make sure you speak out loudly and clear. Go ahead, Mr. Manning.
Mr. Richardson, where does your bond currently set up?
100,000.
Okay, and have you been able to make that bond?
No, Your Honor.
Is there any chance you can make any type of bond in this case?
No, sir.
Okay, do you have any vehicles, homes, bank accounts, or any other assets you can put up for collateral in this case?
No, sir.
Okay, have you attempted to raise money or to get some type of bond situation while you've been incarcerated here?
Yes, sir.
Okay. And you were arrested on July 10th, is that correct, on this warrant?
Yes, sir.
Okay, and you've been in jail more than 90 days, is that correct?
Yes, sir.
Okay, and you're asking for a PR bond this time, is that correct?
Yes, sir.
Your Honor, I pass on this.
So, Mr. Manning, you're showing that he's been in over 90 days already?
Judge, he was arrested in Alabama on this warrant.
So he's only been in maintained custody for about 56 days, somewhere around there, maybe. But you're saying the remainder of that time he was in Alabama, was he extradited or what, do you know why he spent 40 something days?
I'm not aware as to why he spent that long a time. All I know is that he was picked up on the, I can give you the warrant number if that would be helpful.
No, that's okay. I don't have access to that information. I just didn't know if maybe your client knew why he was. Usually it's rare to hold somebody 40 or 50 days on a warrant. Usually they get, notice 10 to 20 days to pick them up.
Yes, sir.
All right, Mr. Harwell, any questions for?
Yes, briefly, Your Honor. Mr. Richardson, you said that you've made attempts to raise the money for a bond. What attempts have you actually made?
I tried to call my dad and see about him trying to get the money, but right now he's financially struggling himself. He told me that he tried to do whatever I could. The last I heard, he was trying to put $100 on my books and he couldn't even do that. So I'm indigent all the way, and I have nothing until I can get out and go to work again.
And as the court just had a question about the time in Alabama, were you in jail in Alabama for anything else? Whether, I'm not asking if you were convicted of anything, just were you in there on anything else?
Yes, sir. Yes, sir.
And can you tell me what else you were in the jail for in Alabama?
Some I have to ask for a moment with my client.
All right, go ahead.
Judge, we're ready again.
All right, do you have any objections to Mr. Hartwell's question?
I do have objections to it as it would prejudice my client. I understand that he has opened the door to be able to testify, ask those things. I've advised him what his rights are. Additionally, Judge, would ask that his answers be limited to for this purpose of this hearing only.
All right, the court will find that Mr. Richardson's criminal history is relevant to the issue of bail. The court will limit the use of Mr. Richardson's testimony today for purposes of bail reduction, solely to bail reduction, not to be used in any other later time. So, Mr. Richardson, you can answer the question that Mr. Hartwell asked.
It was for misdemeanor at the time. That's all. I did.
Sorry, could you repeat? I couldn't quite pick up what you were trying to tell me.
It was a misdemeanor harassment in Birmingham, Alabama.
All right. And was that charge finally resolved?
Yes, sir. Sir.
When was the final resolution? Was it when you were the day that you were transported to Van Zandt, or was it sometime before then?
Wait, sometime before that, sir.
Okay. Do you know the exact date?
No, sir. I just know they told me the moment that I was done that I had a hold on me, and then that was it. I waited and waited, and I was blessed they shot hand.
All right. So you don't know if it was 3 days, 5 days, 10 days that you were waiting for?
It was over 2 weeks, 3 weeks to be exact. Got it. I mean, I know I can't remember the dates. I just know that they told me that they were gonna put an extension, and that's all I heard.
Just a moment, Your Honor, if I could. Mr. Richardson, have you ever been on bond for another case?
Yes, I have.
And did you encounter any issues being on bond in those cases?
Sir.
No further questions, Your Honor.
Mr. Richardson, your issues in Alabama, did they in any way relate to who could be the alleged victim here?
No, sir.
Totally separate incidents.
Yes, sir.
All right. Anything further, Mr. Meany?
Nothing from defense, just argument.
Go ahead.
Judge, there's no exception when a legal hold was put on my client while he was in Alabama jail, because Alabama failed to comply with that or do their duty does not have any bearing on my client's rights under 1751 because it's been past 9 days. We request for a PR bond in his situation.
Hartwell.
Your Honor, I believe that the 90 days wouldn't start to toll until all other business was concluded except for Van Zant's. It's hard to know exactly when that was. It sounds like maybe Alabama may have possibly held Mr. Richardson longer than the 10 days, but we don't know that. I would argue that we can really only count 55 days, maybe add 10 for the statutory requirements, which would put us under the 90 days. And further, this case is an aggravated assault, family violence. And so $100,000 bond in that for that kind of case, state does not believe is unreasonable.
All right, Mr. Meeting, I'm going to ask that you provide the court with additional information regarding Mr. Richardson's legal conviction or for whatever he did over in Alabama. I think Mr. Hartwell's argument does have merit. I don't believe that the 90 days would begin running until all of his other goals have been placed on him in another county. So I would like to have more information on that so I can compare what happened in Alabama to our Texas state law to determine if he is entitled to what he's seeking.
Yes, Judge, I've attempted to reach out to the county in Alabama, but been unsuccessful. I'll attempt to again. I might see. I don't remember if my client was represented by counsel there. I may take another tack and see if we can't get those records another way.
So what I'm going to do is I'm going to take the writ under advisement until we can get more information about that. So the sooner the better, and then I'll certainly roll once I have a good understanding of what happened in Alabama.
Yes, Judge.
All right, thanks, sir. Abraham,
Yes, Your Honor.
is there any update on this concept with this for me on their list?
Your Honor, we're still waiting on our defendant to get here from Henderson County.
Okay,
They're on their way.
all right, so, hey, what I'm thinking is Abraham.
Okay, I'm sorry. She's not in Henderson County. We had him confused, or I had him confused.
Okay, so I show that Mr. Manning still has 5 defendants. It's Thomas has 1. So if we don't have these resolved by 10 till, I'm gonna go ahead and recess 10 minutes.
Okay. Okay, Mr. Manning is ready.
All right, Mr. Manning, come on up.
Judge, we go ahead and call Michael Davis.
All right, Michael Denver Davis, cause number CR 22-176, CR 23-124, CR 23-125, CR 23-149. I'm sure that we're set for docket call on the first one, pre-trial on the middle two, rating on the last one. Let's go ahead and take up a ratings, CR 23-149. Mr. Davis is charged by indictment of manufacturing, delivery, of controlled substance, delivery of water greater than 400 grams.
Judge, actually, if we may, I have been requested to file a motion of withdrawal in all cases. That was filed yesterday and Monday on all cases involved. Mr. Davis was quite clear in his letter that he no longer wished me to represent him. And so I have, at his wishes, filed that motion of withdrawal on all cases.
All right, I've not reviewed that motion. What are his grounds? Is he a hired attorney?
Judge, he did not elucidate that in his letter. All he did ask was that I withdraw. He did not feel like I was accomplishing the things that he was wanting done in his case at the timetable he was wanting them done in. And so he signed off on that motion to withdraw. It is agreed. I've advised him of his court settings per my obligation. And so as to what his plans after this, I'm not sure.
Mr. Davis, are you gonna hire an attorney?
I was looking to, I'm not sure if I can at this time, or if my family has the means to do so.
So you requested a court appointed attorney. I gave you one. Now you want me to have him withdraw, and you're not gonna have, so you're no longer gonna have what you asked for, and you're not gonna be able to hire an attorney to represent you. You plan on just spending the rest of your life in the Van Zandt County Jail? What's your plan?
Oh, no, sir, it's just, it just seemed to be a barrier between me and my attorney, sir, and so I just, if that wasn't there, I definitely wouldn't have even asked him to do so in this case, and I appreciate y'all giving me an attorney, and I appreciate what he has done. It just seems to be a communication barrier between me and my attorney.
So what's your solution to that problem?
I mean, that's up to you, Judge. I'm a pretty easygoing guy, pretty laid back. I don't have any issues with Mr. Manning or anybody else for that matter.
What is it that Mr. Manning is not doing that you think should be done?
During our last setting, during our last meeting, he kind of walked out on us as we were talking, left, and I hadn't talked to him since, and then I got my last court date. I think you were absent. He brought me up in front of, who was sitting in judge for Your Honor, and without talking to me and discussing matters with me, so I didn't really know exactly what all was going on, and that's kind of left me in the dark, and I kind of felt like it kind of threw me under the bus on some things, and I wasn't able to discuss with him, and I haven't been able to talk to him since, and he hasn't discussed anything with me since then, so. But in the letter, sir, I put in there, I'm willing to get over anything and put it all aside. I'm sure he was stressed out. I've had my own stresses with other things as well. I'm sure he has too. He has a lot on his plate, and I've had a lot on my plate, and maybe there was just some, a bad day for both of us. I'm willing to get over it and move forward, or fit or think is necessary, need to be, Your Honor.
Well, let me tell you some facts, okay? Number one, there's not a multitude of court-appointed attorneys available. There's not. In my court, there's less than 4, maybe 4. All right, Mr. Manning's one of them. Okay. The second fact is you don't get to pick which court-appointed attorney you get. Okay.
Yes, sir.
The next fact is you have the right to represent yourself, which I would not advise you to do, considering the charges you're facing. You also have the right to hire an attorney to represent you. That way you can decide when they work, when they don't work, hire, fire, all that good stuff. You're telling me that you can't do that. So then the fact remains is that you can't hire an attorney. And it's not in your best interest to represent yourself. You're left with court-appointed attorney. And the word court appointed means the court appoints, not Mr. Davis appoints. I understand that y'all had a bad day and disagreement, but guess what? My wife and I, we have bad days too. And we have disagreements. And I don't go and divorce her every time we want to fight about something, or every time we disagree, or every time I feel like she's not doing what she should be. She doesn't try to divorce me every time she feels like I'm not doing what she thinks I should be doing. Okay, so if it's an issue of communication, that's one that you're gonna have to work through. If it's something, if it's beyond communication, you can't talk with Mr. Manny can't talk with you, then okay, we'll have to deal with it some other way. I don't know how we're gonna get it done, but I'll have to figure something out. And it's gonna delay your case, it's gonna push it further back in time. That means more time that you sit in the county jail. Let me ask you, Mr. Manning, do you want to respond to anything Mr. Davis said? And also in doing so, you tell me if you believe that the communication is such that there's no longer attorney-client relationship here capable of being had.
Judge, I will say that we did have a strong disagreement at the last time we spoke. However, there has been no actions that I've taken in this case that would undermine his rights or ability to continue defense of this case. We've had one reset since then. I've attempted to come meet with him, but as my client is a trustee, an outside trustee, it has made visiting him difficult. When I came to deliver the motion and discuss that with him, he was not available, and so I left it for his signature so we could get it filed in a timely fashion. I would say that without going into the confidentiality of the attorney-client relationship and going into privilege, that the attorney-client relationship has devolved to such a point that I don't believe I would be able to effectively communicate and represent Mr. Davis in this case. But I also understand, as the court's already pointed out, that options are limited. And I would much rather see him have an attorney that's able to represent him rather than be stuck in limbo for an indefinite period of time. And so if Mr. Davis is changes tune and wants to continue on in that relationship, then I will continue on at the court's pleasure. As I said, I think some of the things that were said may be difficult to go forward in that representation based on our last communications.
All right, I'm gonna reset this case till November 9th. I'm gonna think of how to go over, review the motion, and I'll take it under consideration for the next 30 days.
Thank you, Your Honor.
Mr. Manning just set all the hearings for exactly what they were set for today.
Yes, Judge. Judge, next ready on Mr. Ronnie Cotton.
Ronnie Wayne Cotton, CR 22-240. Mr. Cotton set for pre-trial.
Yes, Judge. We have no contested pretrial issues.
All right, court will set finds that there are no contested pre-trials. Court will set Mr. Cotton docket call November 9th. You ready on anyone else? Do you need more time?
Yes, Judge. I'm ready on Miss Billy Allen.
Allen, go come forward. Billy Jean Allen, CR 21-318, motion to remove.
Yes, Judge. I was appointed to Miss Allen on the 2nd, and looks like also on 18th. I was unaware that she had reached Van Zant County. She was previously in Dallas County and Wood County. So I've not had an opportunity to discuss with her on her file case or her unfiled case. We would request that she be set out for the November 9th setting. So I can check and see what the status of the new case is.
Okay, Mr. Harville, do you have any information on the case?
I can look real quick, Your Honor.
All right, court sets Ms. Allen for hearing on her motion to revoke November 9th.
Your Honor, I don't see a new case with us yet. If it was a recent arrest, it may be something that we just haven't received yet.
And I'll show that it was, I believe it to be a possession of controlled substance. Penalty of 1 to 4 grams. Bond is set at $10,000.
That's fine, that's fine. Mr. Manning, are you ready on Mr. Michael Watkins or Mr. Lopez?
Judge, I don't know where Mr. Watkins went.
I'm about to take off, so I was trying to.
Okay. Mr. Watkins is going to be a reset. I think we've reached a tentative agreement that's conditioned on him getting some things done for probation to go back on probation. And so I will get a reset executed and provide that to the court. But I believe we're close to getting a resolution on his case and getting him back on probation.
So
The only
he was in the jail, correct?
he was, yes, Judge.
We want to set him on October 26th.
Yes, Judge.
All right, court sets Michael Watkins CR 2201 for October 26th.
And Judge, I would just ask if we do get those conditions precedent completed prior to that date, if we could just get the motion to reinstate signed off on.
We'll see.
And then Judge, the last one I believe I have on today's docket is Ms. Kristen Lopez.
Yes, Ms. Lopez, come on up. CR 2357, State versus Kristen Nicole Ramirez Lopez for arraignment.
Yes, Judge, her name is spelled correctly. She understands the charge against her as well as the range of punishment. And at this time, we're pleading not guilty. Request to be set for pretrial.
Well, then November 9th, we can do more time.
Judge, November 9th will be good.
All right, court sets Ms. Lopez for November 9th at 1:30. Ms. Lopez, if you make bail, then your hearings will be at 9 a.m. on that same day. Okay?
Judge, I believe that concludes my business. May I be excused?
Thank you, Mr. Mayor.
Thank you.
State Abraham, are we ready on this Thursday at all?
Yes. She's gonna withdraw the motion.
Okay, I think I heard her say that. All right, then,
Here she is, right here.
hi, Ms. Thompson. I thought I heard you over there. All right, so Ms. Thompson, just so I'm clear, you're withdrawing your writ of habeas corpus on Sadie Murphy's WR 23-81.
Yes, sir. I have spoken to the client. We think that's the appropriate way to go at this point.
All right, thank you, Ms. Thompson. I will note that. And you want me to go, so you're withdrawing it, so I can go ahead and close it out?
Yes, sir.
Okay, thank you, Ms. Thompson. I appreciate you being here.
All right, thank you.
All right, Ms. Abraham, does that conclude our business?
Yes, sir.
All right, thank you so much. I will be back to sign documents for Mr.
Okay. Correct.
So I'm gonna leave all my stuff in the courtroom, run into my business, but I'll be back. Thanks for making this happen.
All right.
All right. We're adjourned.